Your constitutional rights have an expiration date. Not because the Constitution says so. It doesn't. Not because Congress decided. In most cases, it hasn't. Courts borrowed the idea from English law, and that English law wasn't about individual rights. And once you find out the reason, everything starts to make sense. Why many people looking to the courts to protect their rights often get two words in response: too late. I'll show you the exact point where it started and how it made its way to America. And I'll do all of this by simply telling you a few stories, with the first being of an American family forced to move from their home because the government said a war demanded it, even though that war was thousands of miles away, and how when they and others like them tried to get compensation for their lost homes and businesses, the government responded only with deadlines that came too late for most. And finally, I'll tell you a story about a comedian and 9/11 first responders that shows clearly how deadlines are not required, but instead determined simply by who has influence and who doesn't. December 8th, 1941, one day after Pearl Harbor, FBI agents knock on the door of the Nakahara family in San Pedro, California. They arrest Sachi Nakahara, a 56-year-old fish market owner who just had ulcer surgery, on suspicion of enemy activity. No evidence, no charge, no trial. His daughter Yuri is 21. She isn't allowed to see him for weeks. When she finally does, he is emaciated, dying. 6 weeks at Terminal Island Federal Penitentiary have broken him. He is released to a hospital on January 20th, 1942. He dies the next day. By spring, a different government entity comes, the War Relocation Authority. They tell the family and thousands of others like them they have to leave. 10 days, that's what they're given. 10 days to sell their house, 10 days to sell the fish market, 10 days to sell everything they own. They're forced to sell their things to their neighbors. Their neighbors know that they have no choice. Everything they sell goes for pennies on the dollar. Armed soldiers escort them to buses. First stop, Santa Anita, a racetrack. They sleep in a horse stall. The smell of manure still in the boards. Then across the country to Jerome, Arkansas. Barbed wire, watchtowers, mosquitoes, snakes. Yuri spends 2 years there. In 1945, she's released. A bus ticket and $25. She returns to California. The house is gone. The fish market is gone. She starts over with nothing. 3 years later, Congress passes the Japanese American Evacuation Claims Act. The government finally acknowledges what it did. It admits, quietly, bureaucratically, that property was taken without due process. It promises repayment. But there's a catch. 18 months to file your claim. Families have to reconstruct records destroyed years earlier, prove they once owned property, find receipts for homes and businesses that no longer exist. Miss the deadline, even by a day, and your claim is forever barred. The Act limits claims to property losses only. No compensation for false imprisonment. No compensation for lost wages. No compensation for the years taken. Nothing for constitutional violations. More than 26,000 claims were filed. The average payout, $1,400. Most families had lost 10 times that. Tens of thousands more got nothing at all. Where did this idea come from? That rights expire? That there's a deadline to seek justice? For that answer, we have to turn to a disagreement among men selling iron casting in Kentucky, at a time when Kentucky was still considered the frontier. Montgomery Bell sold iron castings to a partnership in Kentucky. He delivered the goods. They agreed to pay $20,000. Year after year passed. The money never came. By 1823, 13 years later, Bell had had enough. He sued. The defendants had a simple response. Too late. Kentucky has a 5-year limit. Your claim is barred. Bell pointed to something crucial. One of the partners had admitted the debt was still owed, and that admission was less than 5 years ago. The acknowledgement restarted the clock. The Kentucky courts sided with the defendants. Bell lost. He appealed to the Supreme Court. Justice Joseph Story wrote the opinion. Story was 49. He'd been on the court since 1811. Appointed by James Madison when Story was just 32, one of the youngest justices ever. He was brilliant, prolific. He wrote tomes on equity, bailments, constitutional law. He taught at Harvard while serving on the court. His colleagues called him a walking library, and he loved English law. the ancient precedents, the traditions stretching back centuries. To Story, American courts were heirs to all of it. So when he faced Bell's case, he looked backward, not to American principles, but to England. He reached for a statute passed in 1623, 200 years earlier, under King James I. Justice Story wrote, "The statute of limitations of Kentucky is substantially the same with the statute of 21 James I, chapter 16. The English decisions have, therefore, been resorted to upon the present occasion as illustrative of the true construction of the statute." Translation: England did it, so it's okay. The Supreme Court of the United States, sitting in the capital of a nation founded on revolution against English rule, was using a law passed by an English king to decide an American case. Story further explained what he thought these time limits meant. It is a wise and beneficial law, emphatically a statute of repose. A statute of repose, a law to let old claims fade away. Montgomery Bell lost. The Constitution's 7th Amendment guarantees a jury trial in civil cases over $20. Bell's case was for $20,000. He got a jury, technically, but before the jury could decide, the judge excluded Bell's evidence. The testimony proving the debt was acknowledged, the letters showing it was still owed. The jury heard a version where the judge had already decided which facts they could consider. They ruled against Bell, and the case didn't end with Bell. It became a precedent, cited again and again to uphold time limits on claims, cited so often that eventually the citation wasn't even needed. The limitation applied. That was it. But Story's wise and beneficial statute, the 1623 law he celebrated, didn't come from nowhere. 83 years before that statute, Parliament had passed the first sweeping limitation law in English history, and it wasn't about fairness. It wasn't about protecting defendants or ensuring fresh evidence. It was about helping a king keep property he took from the church. Henry VIII has a problem. He's 43. He's been king for 25 years. He needs a male heir. His wife, Catherine of Aragon, is 49, past childbearing. She's given him one surviving child, a daughter. Henry has fallen for Anne Boleyn. She's young, clever, and refuses to be his mistress. She wants to be queen. So Henry needs an annulment. He argues his marriage to Catherine was never valid. She'd been married to his brother first. The Bible forbids it. The Pope should grant this. Other kings have gotten annulments for less. But Pope Clement VII won't do it. Catherine is the aunt of Emperor Charles V, the most powerful man in Europe. Charles controls Rome. The Pope is functionally his prisoner. Henry waits, petitions, argues. Years pass. Anne Boleyn becomes pregnant. If it's a boy, Henry needs him legitimate. He needs to marry Anne before the child is born. So Henry takes action. He declares himself head of his own church. The act of supremacy makes it official. Henry VIII is now supreme head of the Church of England. But breaking with Rome isn't just about marriage. It's about money. Scattered across England are more than 800 monasteries, abbeys, and convents. They're not just religious institutions. They're economic powerhouses. The monasteries own about a quarter of all cultivated land in England. They control massive estates, collect rents, dominate the wool trade. Henry is broke. Years of wars and lavish spending have drained the treasury. His father had been frugal. Henry has blown through everything. He needs money. And the monasteries have money. In 1535, royal commissioners fan out across England. They visit every monastery, take inventory. It's called the Valor Ecclesiasticus, the value of the church. They report back to Parliament. The monasteries are corrupt. Monks living in vice. Abbots hoarding wealth. Parliament acts. The Act for Dissolution of the Lesser Monasteries. Every religious house with income under £200 a year is closed. Their land, their gold, their silver, everything goes to the crown. By 1535, Henry wants them all. The larger abbeys are persuaded to surrender. The abbot of Glastonbury refuses. He's arrested, convicted of treason, executed. March 1540, the last monastery, Waltham Abbey, surrenders. In 4 years, Henry VIII has dissolved over 800 religious institutions. Thousands of monks and nuns turned out. Libraries destroyed. Henry now owns all of it. Almost immediately, the claims start coming. Families appear in court saying their ancestors donated land to the monasteries with conditions. Conditions now broken. Former tenants argue their ancient rights should revive. Disputes over old leases, feudal obligations, agreements going back generations. The court of augmentations, created just to handle monastery property, is flooded. Henry's advisors worry about something bigger. What if England reconciles with Rome? What if the Catholic Church uses these old claims to challenge everything? Every lawsuit is a threat. Every old deed, every ancient charter could unravel the dissolution. In 1540, the same year the last monastery surrenders, Parliament passes a new law, the Limitation Act. It sets time limits on claims to real property. Depending on the type of action, 30, 50, or 60 years to bring your claim. After that, too late, barred forever. The timing is unmistakable. This was the first sweeping statute of limitations in English law, the first to impose broad, fixed deadlines across categories of claims, a legal firewall. It now protected the Crown's new land from old rights and ancient claims. The new law made it nearly impossible for the church or anyone else to get the land back. It killed old claims to monastery lands. New owners rested easy. The Crown kept its wealth. By the early 1600s, that fight was over. But England had changed. The economy was expanding. Credit was everywhere. Merchants extended loans. Neighbors made promises. Debts piled up. And so did disputes. In 1623, under King James I, Parliament expanded the solution. The new Limitation Act didn't just cover land anymore. Now, personal actions got deadlines. Contracts, debts, broken promises. The statute's opening made its purpose explicit. For quieting of men's estates and avoiding of suits. Quieting estates, avoiding suits. Not justice, not truth. Quiet. For most claims, the limit was 6 years. Some had 4. After that, your claim was gone. Not because you were wrong, but because the law valued finality more than getting it right. And it's this statute that Justice Story celebrated 200 years later. Wise and beneficial, he called it. A statute of repose. He never mentioned the monasteries, never mentioned Henry VIII, never mentioned that the whole concept was invented to create quiet more than to pursue justice. He just reached for the English rule and planted it in American law. And once planted, it grew. The men who wrote the Constitution knew how to set deadlines. They did it twice, Article 1, Section 9, and in Article 5. Both contain the same date, 1808. The first clause prohibited Congress from banning the slave trade before that year. The second prohibited any amendment that would change that rule before the deadline passed. 20 years, a timer written into the nation's founding document. But look at which direction the clock ran. It didn't say, after 1808, your claim is barred. Instead, it said, after 1808, Congress can act. The deadline opened a door. It enabled government power to end an injustice. James Wilson, who would later become a justice of the Supreme Court, explained it at the Pennsylvania Ratifying Convention. Under the Articles of Confederation, he said, states could import enslaved people forever. But under this new Constitution, after the year 1808, the Congress will have power to prohibit such importation. He called it laying the foundation for banishing slavery out of this country. The timer pointed towards freedom, not restriction. The Fifth Amendment says no person shall be deprived of life, liberty, or property without due process of law. And it doesn't have a time limit. Making something valid for a limited time is what you do for products you sell on infomercials or for coupons on microwave dinners at the supermarket. Not for rights that are self-evident. The founders knew about English law and how it was filled with limitation periods, statutes that killed claims after a set number of years, the 1623 law that Justice Story would later celebrate, the 1540 law that protected Henry VIII's seizure of monastery lands. The founders chose not to replicate it, but it found its way in anyway. William McClunny wanted to buy land, federal land, public land the government was selling to settlers in Ohio. He went to the federal land office in Zanesville with his deposit receipt. He'd paid what the law required. He had the paperwork. He asked the register, a federal officer named Willis Silliman, to enter his application. Silliman refused, said the land was already sold, said it wasn't available. McClunny disagreed. The land was open. The Federal Land Act of 1796 said the register had to accept applications for available land. Silliman was violating federal law, but McClunny didn't sue right away. Maybe he tried other remedies. Maybe he couldn't afford a lawyer. Maybe he thought Solomon would eventually do the right thing. We don't know. But we do know that 13 years passed. And in 1823, McClunny finally sued. Silliman's lawyer had a simple response. Ohio has a 6-year time limit. Your claim is dead. McClunny's lawyer pointed to something crucial. The Federal Land Act doesn't have a time limit. Congress created this right and said nothing about it expiring. So why should Ohio state law put a deadline on a federal right that Congress left open? The Supreme Court ruled against McClunny. Justice McLean wrote the opinion. When Congress creates a right but doesn't specify a deadline, federal courts will borrow the state's limitation period. Sue in Ohio, Ohio's clock applies, even against federal officers. Even when Congress never said there should be any deadline at all. 13 years had passed. The door was closed. Congress didn't close it. The court did. The doctrine kept spreading, case after case, each one citing the one before, each court treating borrowed state deadlines as if they were what Congress intended. The practice hardened into doctrine. By the time it reached constitutional claims, the path was already set. By the mid-20th century, the borrowed deadline doctrine was settled law. Courts didn't question it. They just applied it. Then came the Civil Rights era. Section 1983 of the Civil Rights Act was the beginning of this period. Passed by Congress in 1871 to enforce the 14th Amendment. It gives citizens the right to sue government officials who violate their constitutional rights. Your 4th Amendment right against unreasonable search. Your 5th Amendment right to due process. Your 1st Amendment right to speak freely. When a police officer, a prison guard, or a government agent violates those rights, Section 1983 is how Congress said you fight back. Congress said nothing about a deadline. The courts created one anyway. In 1985, the Supreme Court decided Wilson versus Garcia. The question, what time limit applies to Section 1983 claims? The court's answer, borrow state personal injury statutes. So whatever deadline your state uses for car accidents and slip and fall cases, that's your deadline for constitutional violations. Same Constitution, same Bill of Rights, but different deadlines depending on where you live. Tennessee, 1 year. California, 2 years. New York, 3 years. A police officer in Memphis can violate your rights the same way as a police officer in Los Angeles. The U.S. Constitution's language doesn't change from one state to another, but in Tennessee, you have half the time to seek justice. Miss a deadline even by a day and your claim is gone. Not because you were wrong, not because the officer was right, because a clock ran out. A clock whose origins trace back to a king who needed to keep monastery land. But it's not just geography where time limits don't apply equally. The tale of a comedian's fight for 9/11 first responders shows this all too clearly. September 11th, 2001. 2 planes strike the World Trade Center. Within minutes, first responders arrive. Police officers, firefighters, paramedics, construction workers. They don't wait for orders. They don't ask about safety protocols. They run in. Detective James Zadroga is one of them. 30 years old, healthy, non-smoker, no history of respiratory problems. He spends over 450 hours at Ground Zero, digging through debris, breathing dust. The government tells workers the air is safe. It isn't. Within weeks, Zadroga develops a persistent cough, then shortness of breath. By 2002, he can't walk 100 feet without gasping for air. By 2003, he needs oxygen tanks to breathe. Doctors struggle to diagnose him. On January 5th, 2006, James Zadroga dies. He's 34 years old. He leaves behind a 4-year-old daughter, the first NYPD officer whose death is linked to the toxic dust of Ground Zero. But he won't be the last. Washington, 2010. 9 years after the attacks, thousands of first responders are sick. Respiratory diseases, digestive disorders, cancers that are popping up at higher rates than statistically would be predicted. The original compensation fund closed in 2004. The health monitoring programs are underfunded. Congress is debating a bill named after Detective Zadroga. The House passes it in September 2010. The Senate doesn't vote. 42 senators sign a pledge. They will filibuster all legislation, everything, until a different priority is addressed. Tax cuts. Tax cuts passed 7 years earlier. President Bush signs the Jobs and Growth Tax Relief Reconciliation Act. The centerpiece? A cut to the tax rate on corporate dividends. The legislation slashes the highest dividend tax rate from 38.6% to 15%, the largest reduction in the dividend tax rate in U.S. history. It made income from dividends special. That income is now taxed lower than the money Americans make working jobs. including jobs like the ones running towards falling towers. The cut is temporary, set to expire in 2008. It's extended to 2010. Each time it nears expiration, Congress acts, and acts quickly. In 2010, when most first responders to 9/11 are starting to face the dire but slow-forming consequences of the terrorist attacks of 2001, cancer, breathing issues, cognitive impairments, nearly half of the Senate has a different priority. 42 senators are holding up everything, so stock owners continue getting special tax rates. On December 9, 2010, a majority of the Senate tries to break the filibuster on the Zadroga Act. The vote is 57 to 42. They need 60. The bill fails. 6 days later, Congress passes the tax cut extension. But even with that passage, the Senate doesn't seem to be poised to allow the 9/11 responders bill to go forward. December 16, 2010. A week after the filibuster holds, comedian Jon Stewart dedicates an entire episode of The Daily Show to the Zadroga Act. He brings 4 first responders onto the show, one with stage 4 cancer, another with heart and lung disease, men who ran into the towers, men who dug through the pile, men who are dying. He points out that the same Senate that couldn't find 60 votes for first responders passed the tax cut extension with 81. He points out that Al Jazeera gave the story more coverage than American news networks. The episode goes viral. Public pressure mounts. The White House credits Stewart with revitalizing support for the bill. The New York Times compares him to Edward R. Murrow. 6 days later, New York senators introduce a scaled-back version. On December 22, 2010, the Senate passes it. President Obama signs the Zadroga Act on January 2, 2011. 9 years and 4 months after the attack. But there's a catch. The Victim Compensation Fund gets $2.7 billion, with a cap limiting how much can be paid out in the first 5 years. The deadline to file claims, October 2016. First responders get 5 years. January 2013. 2 years later, the dividend tax cuts are set to expire again. Congress passes the American Taxpayer Relief Act of 2012. For the dividend tax cut, the law does something it never did for the first responders. It makes a lower rate permanent. No sunset, no deadline, no cap. The Zadroga Act, meanwhile, is still counting down. First responders have until 2016. Then they'll need Congress to act again. The healthcare program is extended through 2090, but the Victim Compensation Fund gets another temporary extension. Another deadline, December 2020. First responders are still on the clock. February 2019. The fund is running out of money. The special master announces cuts. 50% for pending claims, 70% for future claims. First responders who have been waiting for compensation, some of them dying, are told the money isn't there. June 11, 2019. Jon Stewart returns to Washington. 9 years after his first intervention, 18 years after the attacks, he sits before the House Judiciary Committee. Behind him, rows of sick and dying first responders. In front of him, rows of empty seats where Congress members should be sitting. The next day, the committee unanimously passes the bill. In July 2019, President Trump signs the Never Forget the Heroes Act. The fund is extended to 2090. The cap is removed. 18 years, 4 acts of Congress, 2 Jon Stewart interventions. A national shaming. That's what it took to give 9/11 first responders the support a nation promised them. But even then, Congress couldn't help itself. Old habits die hard, I guess. The First Responders Fund runs until 2090, 71 years, a long time, but still a deadline, still an expiration date, still a clock. The dividend tax cuts have no such deadline. When Congress made the lower rate on investment income permanent in 2013, it didn't write until 2090. It wrote permanent. For investors receiving dividend checks, the special rate lasts forever. For first responders who ran into burning buildings, there's still a date on the calendar. Still a year when someone will have to ask, what happens next? In 2010, 42 senators shut down the entire Senate, filibustered every piece of legislation to make sure investment income kept its preferential treatment. No one shut down the Senate for the first responders. It took a comedian, twice. It took 18 years. And even now, even after everything, one has a deadline and one doesn't. The Constitution doesn't put expiration dates on rights. Congress and judges do that. To learn about other quiet mechanisms that can and often do impact your life, and not always for the better, check out my Plain Meaning channel on YouTube for more episodes. And if you watch them all, don't worry, because I release a new one every Tuesday.